Thank you. So the purposes of today's seminar is to discuss the legal recourse for domestic abuse survivors. Obviously, domestic abuse is in the domain, and there are many changes which are happening across the legal systems to support victims of domestic abuse. And I'm just going to go through quite briefly some of the recourses that are available to victims. Next slide, Fatima. So just as an overview, what domestic abuse is and what does it actually mean? Domestic abuse, as it stated, is an incident or a pattern of incidences of controlling, coercive, threatening, degrading, and violent behaviour, and that does include sexual violence. The majority of cases of domestic abuse are perpetrated by somebody you know, but they can also be a family member or a carer, but they've got to be personally connected to the victim. And in the vast majority of cases, it is experienced by women, which is perpetrated by men who are either their partners or their husbands. Next slide, please. So what does domestic abuse actually include? There is a list of it, although it's not recognised legally, and in due course that will be with a new domestic abuse bill coming out, which has been in Parliament quite recently, but it's not limited to the following, which is coercive control, which is again a continuation or a pattern of intimidation, degrading, isolation, and the control using threatening or physical or sexual violence. Psychological and emotional abuse. A lot of people don't think that that is domestic abuse, but it is. People and victims especially think that domestic abuse is a physical act or sexual abuse. It can also be financial or economic abuse where your finances are controlled. It can also be harassment and stalking where there's continuation of phone calls, threatening messages, emails, social media, and online digital abuse. Next slide, please, Fatima. So just by way of examples, what that means. So there is some terminology which is associated with domestic abuse, as in direct physical abuse, which can include assault, rape, damaging of property, coercive behaviour, again, trying to harm, punish or frighten somebody by using violence, threatening, humiliation, degrading, intimidation. The other types of abuse which are not physical, again, can be threatening, where there's consistent criticism within a relationship. There can also be harassment. And then controlling behaviour, such as isolation, not allowing family members or friends to be a part of a support circle, reducing your independence, so not allowing your movement, restricting you from what you can do, where you can go, and again, trying to control behaviour. A big thing recently has been financial control, because a lot of victims are homemakers and are solely reliant on partners or husbands to be financially supporting them. So again, you know, a big way of how that abuse is controlled. Next slide, please. So what are the types of orders and legal recourses that are available to victims? So some forms of domestic abuse are criminal offences. Sorry, I just need to move away from. Oh, sorry. Okay, so they are criminal offences, especially in relation to sexual assault, and generally they should be reported. And I'm, as I've mentioned in many of my sessions before, is that I am a big believer in the social pressures and cultural pressures that are surrounding victims, especially when you're from the Asian community, about how difficult that can be, the stigma attached to it, the worry, being scared as to whether the police will actually take any action, and what the consequences of that may be. The police are now have the ability to issue domestic violence protection notice, or they can apply for a domestic violence protection order, which similarly is like a restraining order, which will prevent any perpetrator from perpetrating that violence towards you. And the police can turn that around very, very quickly within 24 hours or immediately in some cases where the abuse is severe. So as much as I understand the stigma attached to going to the police, and in the past, if you have maybe gone to the police and you may not have the confidence in the police that they will take any action, I will always say that, you know, do not give up, because it's something that you should do. It's always the first recourse to get the protection, especially if you have children. So in addition to what the police can offer you, the law itself also allows you to apply for injunctions to protect yourself. And there are two forms of that, one being a non-molestation order and the second being an occupation order. Next slide, please, Fatima. So just to define in the court system what the definition of molesting is understood to be behaviour that is harming. It can be troublesome, it's annoying, it's an inconvenience, which is perpetrated by an associated person to you or to any relevant child. And again, molesting can be direct, and it includes a range of behaviours such as physical harm, verbal abuse or threats, or pestering from another person. So it could also mean that you are protected from any other third person contacting you within any order that you may retrieve. So molestation can also be committed indirectly, again, through social media, through a third person, especially with Asian families, where you have in-laws, family members who are living with you. Again, that would all still be considered as molestation, and any intimidation and pestering from them, such as persistent messages, phone calls, again on social media, putting posts up on social media, which is a big thing now in the court domain, which can become threatening, and it will result in harassment. Again, molesting can also be the physical side of things, where there's pushing, punching, slapping, you know, again, all of these things that the court understand to be molesting. Next slide, please. So who can actually apply for a non-molestation and occupation order? The whole thing is that these types of orders are, you can only apply for them if you are an associated person, so that you have to have that personal connection with that person. It doesn't mean that you have been in an intimate relationship with somebody. It could be a relative, a family member, your husband, your civil partner. It ranges. The definition is a broad range. It could be people living in the same household. So it could be a lodger, could be anybody within, but they've got to be associated with you somehow. Next slide, please. So before I really go into the orders that are available, I just wanted to touch upon emergency orders, and many victims sometimes are not aware that they can apply for an emergency order. And the protection that gives you is that if you are worried that any order that you try and seek from the court may spark a reaction from the perpetrator, then you can make an application from the court on a without notice basis. I mean, they used to be called ex parte orders, and they sometimes can be referred to as ex parte orders. And what that means is that the perpetrator will not have any notice of your application to the court. And what the court will do is they will list it for an emergency hearing for you to have an opportunity to present your case without that person knowing. You can then secure an order, and the other person will then be personally served with that order. So therefore, that you don't have to have any communication or any contact with the perpetrator once an emergency order has been secured. Next slide, please. So what is a non-molestation order? A non-molestation order is essentially, it's to stop somebody who has perpetrated violence or domestic abuse against you. They are often referred in the court system as the respondent. And what the court can do is they have the power to make an order to stop them from using or threatening violence against the victim, who are referred to as the applicant, using or threatening violence to a child or any children involved in the family, molesting a person in any way whatsoever so that they can't contact you, they cannot come within a certain vicinity of you, they cannot contact you unless it's usually if you do have solicitors appointed, then there's a provision that you can have contact only via solicitors for communication purposes. Even if you have children, if you don't want to have any communication with them. And the whole purpose of a non-molestation order is just to keep that person away from you. And they could be, so that, like I said, not within the vicinity of your home, or even in the workplace or any other third place. Sometimes I have it where it can be even the family places. So the parent's home address can also be included in the non-molestation order to prevent somebody from coming to that workplace or the home place or the family place. Next slide, please. So in order for their application to be successful, there has to be evidence. Now, this is always a tricky, because over the years, and as the evidence has always provided, that victims of domestic abuse rarely report that they have been a victim of domestic abuse. So how do you actually document them, and how do you bring forward your evidence? And I will always say that if a victim is scared to go forward and seek help from a third agency or the police, then any form of documentation that they can provide is text messages, emails, even sometimes recordings. And I know that sometimes people have a negative view about recording the other person because we never know what circumstances the recordings have been made by. But that's always a way to produce some level of evidence if you are too worried about seeking the help that you need. But essentially, there needs to be some level of evidence to show the court why this non-molestation order is needed. And obviously, you have to show that you are in need of protection, any children that are needed protection, and that order is required to ensure that the behaviour of the respondent stops. As I've said, an order, even if it's done on an emergency basis or even if it's done with notice, that order has to be served on the respondent in order for that order to be effective. So if you secure a non-molestation order and you don't serve it on the respondent, you cannot rely upon that order. So if you go to the police to say that you've got a non-molestation order, the first thing they will ask is whether the order has been served on the respondent. If you have solicitors acting for you, obviously that will take due process, because a process server can be arranged so that you don't have to come face to face with the perpetrator to say that there's been an order made. So an independent person can serve them, or it can be someone from even the court who can serve the perpetrator in their workplace, in their home environment, or wherever they may be. As long as that service has been effected, then that order will then be legally binding. A non-molestation order is usually made between 6 to 12 months. In some of the severe cases that I've come across, it's been a lifetime non-molestation order, but again, that is where there have been extreme circumstances, or there's been an order made until further order of the court. So it can be, long. There can be some longevity in it if the circumstances are severe to warrant that. Breaching of a non-molestation order is a criminal offence now. It's punishable for up to 5 years, or it can be considered as contempt of court. I've had non-molestation orders where there have been so many breaches. Whether the police really take action the first couple of times, I would say they probably don't, which is really difficult to deal with. I think until there have been significant breaches and there's been sufficient evidence to show that those breaches have occurred, only then really the police do take action, which is a sad state of affairs in itself. But again, the order is there and it is a criminal offence. So the perpetrator can be brought before the court, not only just in the civil case, but also as a criminal in the criminal courts also. Next slide, please. So the other order attached to the injunction is an occupation order. And an occupation order is it determines who will live at the family home. Now, obviously, if parties are separating and are finding it very difficult to live together, and there has been a lot of domestic abuse within the relationship, then one party can ask the court to make an occupation order. Occupation orders can be very tricky. The courts do not just give out occupation orders. The whole purpose of them is for the other person to be excluded from the property, and there are certain rules or they can set out certain rules where the property can be shared, so there can be boundaries to have so both parties to have an occupation order, and boundaries to be set as to who can come into a particular area at a particular time. But again, I do find within my experience that sometimes that doesn't work, especially when there's a perpetrator and a victim living under the same roof. I also find that victims are under an illusion that they do not have the right to make an application for an occupation order because they're not named on the property. If you are a victim of domestic abuse, you don't have to be an owner to make the application for an occupation. You can make it as long as you've occupied that property. The court will obviously look at what the merits are. There is a certain criteria to meet in order for an occupation order to be granted, because the courts are not just going to make a perpetrator homeless. That's not what they're there for. But they will apply a balance of harm test to see if a perpetrator continues living within the home environment, what the harm is, not only to the victim, but also if there are any children involved in the family. Next slide, please. So an occupational, like I said, it's a very temporary living arrangement. Occupation orders are made for up to 6 months, but again, you can extend those orders, but they are a very temporary arrangement. If you are in the middle of divorce and financial proceedings, it works as a short-term measure, but essentially they are not there granted on a long-term basis, because the courts do believe that there needs to be some conclusion of what the living arrangements should be for both parties, even be it that that is via divorce and financial proceedings or cohabiting parents. So, and we have this a lot, especially when women are not, do not have a civil marriage, or they are married Islamically. They do not have the right, the perpetrators argue that they do not have a right to occupy the property. And I'm just going to touch upon this because this is obviously maybe something that needs to be covered in another session, is that cohabitees have a different legal status as opposed to married women. But if you do have children, again, you have the right to occupy that property, again, and for another forum maybe, but a very short-term arrangement if the court do make the occupation orders. Next slide, please. So what's the test for an occupation order? The court will have regard for the following circumstances, and I have listed them down. But again, not limited to that. They will look at the overall picture. What I find is that perpetrators, like I said, they are the breadwinners, and the victims are usually the homemakers. So they don't have the access to the recourses that they need to potentially move on and find their own accommodation. So the court will be looking at all of that. So they'll be looking at the housing needs of each of the parties and of the children, what the financial resources are of both of the parties, and essentially what will happen to the parties if an order isn't made. And they will also have to take into account the health and welfare of the parties and of any relevant children. You could always plead conduct in these type of applications, that the conduct of the perpetrator has been so difficult, which is why you're asking the court to make an occupation order. And there's various other factors, such as how long the parties have been married or cohabiting together, and what and if any time has lapsed in between the parties not living together. Because I've had occasions where the victim has left and still sought an occupation order, even if they were living in temporary accommodation, but then have gone back to the former matrimonial home and got the perpetrator out wanting to occupy the former matrimonial home because of the sake of the children, for schooling purposes, etc. So it can happen again, but you've got to be able to satisfy these type of requirements. Next slide, please. I just wanted to touch upon this, although this is not a legal recourse, but I just wanted to make people aware that what Another form of protection is registering something called a matrimonial homes right. And a lot of ladies do not know this when they come in for legal advice. But this is something, again, that if they wanted to, they can also do themselves. Is registering a home rights is when if you have a family home which is owned by your husband or your spouse or your civil partner or your just your partner, and you have the right to occupy that property. If you're concerned that the partner may dispose of that property, or they sell it, or they remortgage it, you have a right to, and if you have a right to occupy that property, you can register a home rights notice with the land registry. And what that does is it protects you in the long run, so that the other person cannot just dissipate their assets. And if somebody tries to sell a property, if the land registry will automatically notify you or your solicitor to say that this person is trying to either remortgage, sell, or raise funds, or put a second charge on a property, so that you are then aware, because it may be the case that you are occupying premises, and the other person in the scenes at the back is trying to get rid of that property. So I would always urge people to register a home rights notice on the property, just so that you are protected. The person who owns a property will always be notified by the land registry that you are seeking that homes right notice, or that you've made that application. 9 out of 10 times, the land registry will just enter the notice. But again, if the other person wants to contest it, they can. But if you are married, or even if you hold the property jointly, I would always suggest that you still make the application, only because then, even if I've had cases where the partners fraudulently signed a transfer document or remortgage document, and the other person hasn't known about it. So if home rights notice is on the property, the other person will always be notified in writing by the land registry. So just gives you that extra protection if you need it. Next slide, please. So how do you apply for any of these orders, and specifically non-molestation or occupation order? So it's a formal application to the court. It's done on the form FL 401. You have to accompany a detailed statement with the application, only because the court has to understand what the position is, why are you seeking the order, where's the evidence, and what order is it that you're actually seeking from the court. So the court will want you to detail all of that information. There was a time when these cases, these applications, sorry, did incur a court fee, but the court fee has now been waived, so there isn't a court fee any longer. As I've said, if you're making an application on an emergency basis, what the court will do is they will hear your application straight away, and they will set the date 7 to 14 days thereafter, and they refer to that as the return date. And once the respondent has been served, they have an opportunity to then put their case forward back at the return date. If it's the case that the respondent does have notice of the hearing, it will be listed in the same way, where both parties will then have an opportunity to attend and present their case. Next slide, please. At the return date, what the court will look at is what are the real issues. If the court have already made a non-molestation order on an emergency basis or otherwise, that will continue until the conclusion of the proceedings. But what essentially the court are going to be looking at is what are the real issues in this case. This can also include things as such as police disclosure. If police have been involved with your family, the court will want to see that disclosure and what's in it. That will also determine who's telling the truth and if you have reported it. They would also be looking at medical records. So say if you've confided in your GP, or if you've had any physical issues as a result of domestic abuse where they've been documented, again, that's always very helpful. If there are any issues in relation to alcohol and drugs, the court can always order that there's some level of testing there if it's necessary. And I've only just marked this very briefly, is that the court may consider that the necessity of finding a fact. And what that means is that if both parties make allegations against each other, and usually in these cases, that's what happens, the court can ask the parties to file schedule of allegations, which means that the court want to see who's actually telling the truth. They will ask both parties to make a schedule with up to 5 allegations along with their evidence, and they will then list it for a hearing where they will then ask both parties to give evidence, and they will determine as to who they believe is telling the truth. It's all based on balance of probabilities. Is it probable that this happened? Is it probable that this person behaved in such a way or perpetrated that abuse? If the court determined that there are findings made against either party, they will then make the necessary orders that they need to. This type of hearing can also be amalgamated into a final hearing. So there is a due process that has to take place. There are anywhere between 3 to 4 hearings that will happen, and at the end of it, the court will either give you their orders, or they will ask you to come to some agreement where undertakings, which are promises to each other, in the same way that a non-molestation order takes place, can be agreed. Otherwise, the court will then grant final orders. Next slide, please. So the other thing just to touch upon is funding, because as I say, that domestic abuse has now played a big part in how funding takes place by the legal aid agency. Legal aid is available if you satisfy the requirements, and there has been a lot of scope in the government at the moment as to the funding that is available for domestic abuse, especially if you hold property together, which I will touch upon later. But essentially what you have to show is that you or your children are at risk from your partner, and that has to be documented. There has to be evidence to show that. And that can be done by either the courts, if you have a non-molestation order in place already, if you have been referred to MARAC, and that would be via the police. Social services, they can always provide you with evidence or a letter to confirm that you are a victim of domestic abuse. A letter can also come from a health professional, such as your doctor, your nurse, midwife, psychologist. If you are in a refuge, if you've had to flee from domestic abuse, your refuge manager can also give a letter. If you are receiving any support from a domestic abuse agency or a support service, they can also give you a letter just to confirm that you are a victim of domestic abuse. And there are other set examples as to who can provide you with them. What the legal aid agency do is that they are very strict on their criteria at the moment. They have produced template letters which can be found on the .gov.uk website. And they set out what assessments need to be done in order for the professionals to confirm that you are a victim of domestic abuse. What I find, especially with GPs, is they do not document this well enough. And what they tend to put in their letters is that because you have told them that you are a victim of domestic abuse, they put that into the letter. But what has to happen is that in their professional capacity, they have to confirm that you are a victim of domestic abuse, and only on that basis would any letter be accepted. So this is the first part of legal aid funding, is that you have to satisfy the merits by confirming that you are a victim of domestic abuse. Next slide, please. The second element is that you have to pass a financial assessment, which is called the means test. Now, the means test, it looks at your income and capital separately, and you have to pass both in order to get legal aid. So income, if you are on benefits, so if you are on universal credit or if you are on any ESA, you are automatically passported, which means that you don't have to carry out assessment. What actually happens is the legal aid agency contact DWP via your national insurance number, and they would do a check to confirm that you are actually on the benefit that you confirm that you are. If you are working, your net income cannot exceed more than £733. There are deductions that can happen if you have children. Then there are certain deductions that can happen, or if you pay a mortgage or if you pay rent, that would all be taken into consideration. Capital, now this is where is always a sticking point. If you have any savings of more than £8,000, you wouldn't be eligible. If you have any money in a bank account, again, ISAs, bonds, shares, or any other financial assets, again, the legal aid agency do a calculation, and they have their own criteria as to whether or not you would be eligible on that basis. A lot has happened. There was a case recently at the Court of Appeal where a lady owned a joint property with her husband, and what the legal aid agency said was that she had access to the equity in that property, therefore she would not be eligible for legal aid just on the basis of her capital, although she was on universal credit. Now, that has been successfully appealed, which means that if you do have a property that you own jointly with your husband or your partner, what the legal aid agency are now doing is they are applying something called a waiver, so that they will not be considering that property as part of your capital. They will also be taking into account your mortgage payments and the overall amount of the mortgage, as deducting that as part of your capital if you do have properties. So if you want funding just for the purposes of seeking these orders, then it's likely that, you know, if you are on benefits and you meet the other criteria, that you can secure that funding even if you have property. Next slide, please. So that's the end of my legal jargon bit there. So if anyone does have any questions, I'm happy to answer them.